Hi, this is Howard Kahn today, and I want to thank you all for positively commenting on my prior videos. They're fun to make. I hope they're fun to watch. I hope they're informative, and I really appreciate the interest. Today I want to talk a little bit about estate planning. There's basically 5 documents you use for estate planning. The first is a statutory durable power of attorney. The second is a statutory durable power of attorney for health care. One would think that they're the same, but they're not. The third one is a medical directive. The fourth is a declaration of guardianship for yourself or your minor children. And the fifth would be an actual will, last will and testament. Statutory durable power of attorney is exactly what it says. It's a statutory document. The legislature has passed a statute saying if you use this form, it works. And that must be signed by the principal designating an agent. That document just needs to be notarized. So you just have one person signing, one person notarizing, that's it. And that's the principal signing. Then you give a copy of the original to your agent. Durable power of attorney for healthcare, though, is a little different. It does not need to be notarized, but you have to have 2 witnesses who are not agents under the power of attorney. Very interesting distinction there, but that's the way it is. Third is a medical directive, needs to be notarized as well, and that is to instruct your physicians not to do heroic actions in case you become incapacitated such that you're not able to function well. Terry Schiavo is the poster child for that. Go ahead and sign those medical directives. Last one is declaration of guardianships for later incapacity of yourself or for incapacity of a minor. Grandma and grandpa taking kids to Disneyland, you want the parents to sign a declaration of guardianship for the children so grandma and grandpa can make decisions, and they're valid documents. And the last document is, of course, a will, last will and testament. There's 3 types of wills in Texas. You can have an oral will in Texas, believe it or not. It can be oral as long as there's 3 witnesses and then you're on your deathbed. Second kind is a holographic will. Holographic will is a will written completely in the person's own handwriting. No typing whatsoever, must be completely in the testator's or testatrix's own handwriting, and that's a holographic will, perfectly valid. And the third, of course, is the normal will where you sign it, you have 2 witnesses. You may attach a self-proving affidavit to both the holographic will and a standard will, and that will be just fine. It has to be written in a certain way, but that's in the statutory book. Here's the book, State Codes. It's roughly 1,500 pages. You can read it. Have fun. I've read it several times. I use it every single day. Howard Kahn, Lone Star Lawyers. You have a great one. Bye now.